Good afternoon, friends. Let's just wait for a minute or so for uh, the participants to join in. Pleasure to be co-hosting this very different webinar. Usually, we have a webinar on a technical topic. Today, it is to familiarize Taxsutra subscribers with a new tool that we have launched in conjunction and collaboration with Chartered Accountant Mr. Ganesh Rajgopalan. Ganesh sir is a well-known author. Has published a book for us, co-published by Taxsutra Reservoir and Oak Bridge on copyright. Royalty. That's a bestseller book available on a digital platform. Taxsutra Reservoir is a prolific speaker on several platforms, and academician. Takes a very keen interest in the technical sessions, the group discussions at the chamber and the BCA. And as I've already said, he's a chartered accountant. I'll give a brief introduction of, so I have already been brief, but yes, a little more. He was one of the two branch reporters for India for the IFA Cancun Congress in Mexico 2020 on the subject of restructuring the treaty network, dealing extensively with MLI and its impact on double tax treaties. He also has a chapter contribution on the topic MLI scope and interpretation of terms for the compendium on the multilateral instrument published by the BCA in 2020. He also presented a paper, Tax Treaties and MLI, Interpretation and Interplay, and the annual BCA International Tax and Finance Conference in April 2023. He was awarded the Heather Self Gold Medal in 2013 for outstanding first in the paper on principles of international taxation, and John Avery Jones Medal in 2016 for his extended essay on interplay of copyright law and taxation for ADIT, added qualification by the Chartered Institute of Taxation, UK. He's authored the book, as I said, published by us, Taxation of Copyright Royalties in India. He also contributed to the revision of Sampata Iyengar's commentary, which again, the digital rights are with Taxsutra Reservoir, and he is a prolific both speaker and author. Ganesh sir, thanks so much for this session. So why we are here, Ganesh sir will first bring up the screen and then maybe I'll take just a minute more to tell everyone why you all are here.
You can see the screen?
Yeah.
Okay.
Yeah, this is the home page of Taxsutra. We now go to the MLI page. Yeah. Here we go. The need for this utility is here. Ganesh sir will also tell us why we need this utility, how it's going to make our lives simpler. Maybe you'll take a little bit of time to get conversant with this tool, but once you get your hands on it, I think this is a superb research tool. You can't do without it. We all know that MLI has made our lives very tough. It's an interplay of so many treaties, so many positions that we have to rethink. It's essentially an attempt to redo 3,000 tax treaties or so with the stroke of a pen or with the stroke of 120 pens, and that is what the OECD has attempted to do, and to give credit to them, quite successfully so. Now that is where we are as far as implementation of BEPS through the MLI is concerned. Now what happens next? Now that you have these treaties, there are some countries which have said that no, they have some reservations. There are some who have said, okay, we agree to these positions, but not to these positions, and so on and so forth. So here is where some complication comes in. So to be able to read the treaties, as per the different country positions. Ganesh sir has brought out this tool, and we at Taxsutra are quite thrilled to collaborate with sir on this. And I requested sir that please take a training session so that our subscribers are conversant with this tool. And in case you all have any queries after that, we'll be happy to take the query right here. You can post them on the chat box, or you can even raise your hands. I'll try to unmute some of you. I'm sure the questions would be common by and large. And if after that, if you have any issue, while doing the navigation, please feel free to reach out to the Taxsutra and your relationship managers. On that note, I hand it over to Ganesh sir. Ganesh sir, first of all, thanks so much, for this collaboration, and we really look forward to adding a lot of value to our subscribers and readers through this tool. This is a subscriber-only tool available only to subscribers of Taxsutra's portals. Ganesha, on that note, over to you.
Thank you, Arun. Thank you, Taxsutra, for this invite, and also for hosting the tool on your website. The need for the tool is so in your face. It's so apparent that when we start interpreting the MLI, the amendments or the modification the MLI seeks to bring to the double tax treaties, so it's very evident that there is a need for something like this, which by which a person can easily refer the changes which will be made, and then take his own call on the extent of the impact these MLI will have on the double tax treaties. The seed for this tool was during the height of COVID. So sitting at home, twiddling thumbs, doing nothing. This was a good pastime I had. I was trying to understand what this MLA was all about, and that lockdown helped in giving me the time to go through each position, India's position on the MLI as well as the position of its treaty partners, and then to make sense of what are the MLA document. The MLA document itself is a very complex document, complexly worded document, though the effect it seeks to bring and even the extent of the effect it brings is quite limited. It is not as pervasive as I initially thought it was, but the document and the language of the document of the process is so complex that it's very intimidating for anyone to make some sense out of it. So now this tool seeks to do exactly that. It's a challenge. It has been a challenging task. Identify the various positions of India and its treaty partners and bring out their notifications and reservations in one place. So at a glance, use the clauses in the MLI to interpret those reservations and notifications and ultimately bring out the result. What will get modified in any of India's treaties, tax treaties, because of MLI? That is the whole objective of this exercise. And I believe that this tool largely does so, would help any practitioner to get a hang of MLI, to get a hands-on exposure to how to interpret MLI. Of course, the legal documents are there in the OECD website, OECD being the secretariat to the inclusive framework. The legal documents has to be referred from that site itself. And if this is freely available, it should not be a problem at all to access those legal documents. What this tool will do is sort of give you a ready reference, whereby you can get an immediate idea of what gets changed, and at the same time you can go back when you have an actual article in a treaty which is to be interpreted in a live manner. Go back to the legal documents and confirm the interpretation what is given here. Or rather, I would not say an interpretation, confirm the information which is given here. I've desisted from giving any interpretations here for the simple reason that interpretations are always opinions, and opinions can always be multiple. And one should not get what I will say, getting into an interpretative exercise would mean that it will not no longer remain a tool, it will become a sort of a commentary. So to that extent, I have desisted from giving interpretations, but I will take you through some of the nuances which this tool will help one to understand where those interpretation gaps lie. There are gaps, like in any interpretation of law or a document. There are gaps that is going to come out in litigation in the coming years. But today we will know what those are, at least what I've identified to be those gaps. So we also have a database of the OECD. I'll just take you to the database for a minute so that you people would have already seen it. That will be good. But then, if for those who have not seen it, so there's a OECD MLI database, which is again available on the OECD website. The purpose of this database is something is vast, in the sense that they are trying to match the various positions on various articles by various countries, amounted to almost 3,000 treaties they are trying to analyze. And in that respect, they have given this as a tool. So this is a Microsoft BEPS MLI matching database. So now here we have two jurisdictions. You select, let us say, India on the one hand, and let us say Estonia, the treaty partner. So India, Estonia, jurisdiction 1, jurisdiction 2. Then it tells you each when the MLI was signed, by each countries, and when it was ratified, when did it enter into force, what is the status, whether it is definitive or whether it is provisional, whether synthesis text is available or not. And for each article, it gives you a sort of a snapshot, a result of what that MLI will do to article, let us say, Article 2 of the MLI. So this agreement will be a covered tax agreement because both the countries have notified the agreement as a CTA. Like dual resident entities, Article 4. This article will not apply. Why? It does not tell you. Probably because one or the other country would have reserved this article in its definitive position. So this is the sort of a brief coverage of the OECD MLI matching database. Now, the MLI decoded, the tool here is India specific. It covers only India's treaties. So ideally, it will focus on only the treaty which India has with its treaty partners, and the MLI impact, the impact of the MLI on those treaties. Being having a narrower coverage, it is able to dive deeper into the positions, deeper into the resolutions and notifications, and also the articles which get impacted. So what I'll take you through the impact summary first. So we have so many tabs, but let us look at impact summary. We can go back and forth. That's not a problem. So let's say I take up, okay, I've selected Lithuania here. Let us say I select Estonia. This is the one which we saw there, right? So I type here Estonia. Okay. Now what we have here is something similar to what you found in the OECD database, but here it will be a lot more detailed, and it will give you a reason why, or if at all, the particular article will get amended or not. Like for instance, you see MLI Article 4 we saw in the OECD database. Article 4.3 remains unmodified. Why? That is because MLI Article 4 would not apply as the other contracting jurisdiction, CJ's contracting jurisdiction, has reserved that article in entirety. So you're getting a reason here for the change or lack of it. So this is the difference between the OECD database and the tool here. The tool what we have here is, as I said, India specific. For it'll give you the changes. It will also, which is given in the OECD database as well. But here it will also give you a reasoning why or why and to what extent the change takes place. So there's a difference between the two. So now here, if you see Estonia, now there are substantive articles in the MLI are Article 3 to Article 17. So you will find for each article the existing CTA provision and its impact and the explanation for the impact. So you are able to come to the conclusion of what the changes would be. Okay, like for instance, here, let us say Article 9. Article 9, there are Article 13.2 gets modified. That's Article 13.2 is the Article 13.2 of the India-Estonia Treaty related to capital gains. Article 9.1, which is MLI Article 9.1, would not apply as both contracting jurisdictions have opted for MLI Article 9.4 and notified their choice. And Article 9.4 would replace the CTA provision, which is Article 13.2, as both contracting jurisdictions have opted in to Article 9.4 and notified that existing CTA provision by the article of the MLI. So the reference to which particular sentence of the article of MLI, which is through which this impact is being given, is also captured in the tool. So the depth of information which is available is much more, it's much deeper than what you find in the OECD database. OECD database, by its nature, I will have to be a lot more superficial because it has a lot wider coverage. Here, as I said, being more specific, we have a chance to go deeper into the issue and understand why a particular change takes place. On the left side, you see here, it gives you the snapshot of the treaty itself. What all happened? MLA, when was the MLA signed? What was the definitive? When was the definitive position deposited by the other country? What is the entry into force for India? What is the entry into force for the other jurisdiction? And later on, the entry into force is what will apply. So it will be 1st July 22. Then entry into effect for other taxes, entry into effect for withholding tax for India and for the other country. So here at a glance, you find for that particular treaty, the entry into force of the MLI as well as the entry into effect for withholding taxes and other taxes for India and for the other country, which can be different. So that information is captured here on the left side. Now going forward, after the impact summary, let us look at the detailed view. Detailed view, we have chosen Estonia in the earlier tab. So that continues, that gets remembered. So you don't have to again type or again select a particular country. Of course, you can change this at any page, in any of the pages you want, and you will get the changed country name. Here you can select the particular article which you want to examine. Let us say we examine article, that is MLA article. Let us say we examine Article 4, for instance. That is a dual resident entities. Here, India's reservation is given. India has not reserved the right for entirety of MLA Article 4 not to apply, while other contracting jurisdiction has reserved the right for entirety of Article 4 not to apply. Which would mean, since one of the countries have reserved Article 4 itself will not apply. So India would, of course, since it has not reserved, it has notified Article 4.3 of the TTAA. But because Estonia has chosen to reserve Article 4, it will not apply and it will come Article 4.3 remains unmodified. So you get that impact of what the reservation was, what the notification was, and the compatibility clause. Here, of course, since the clause itself does not apply, it is not reproduced. And the explanation, which is actually the same thing which is there, which you found in the impact summary, which is getting repeated here so that you don't have to go back and forth between the two pages. It tells you what the existing CTA provision is also, so that you can make up your mind to what extent a particular article of MLI will impact the existing CTA provision. So here, MLI article text is being captured here and existing provision is captured here. So based on, because both have to be read together, the MLI articles do not act as a protocol. They don't substitute the existing article. They have to be read alongside each other. So you have both in front of you. You can take a decision how this article, in what manner it will get modified, taking into account the MLI article text. So this is given on one tab, so it can easily, the reader can easily make a comparison between the two and come to a conclusion. Now let us look at Article 9, because we saw that article as well, right, in the earlier page. So in Article 9, what has happened? India has not reserved the right for Article 9 not to apply, nor has the other contracting jurisdiction. It is also not reserved. India has notified Article 13.2, and India has chosen to opt for Article 9.4. This is also a notification with the India's positions. And other contracting jurisdiction has done the same thing. It has chosen Article 13.2 and has also notified Article 9.4. Now, the compatibility clause is reproduced here. Compatibility clause is nothing but a conflict rule, in the sense that when there are, the MLI does not substitute the double tax avoidance agreements. MLI has to be read along with the double tax avoidance agreements. But when you read alongside, it means both exist. When both the agreements exist, both are international agreements, if they both exist at the same time, only one can apply. It is not possible that both can apply. So to the extent to which one will apply is what is given in the compatibility clause. The conflict between the DTAA and the MLI, because of which MLI modifies the DTAA, that conflict gets resolved or a rule, the conflict rule is given through the compatibility clause. So here it says MLI Article 9.4 shall apply in place of, on the absence of a CTA provision, providing that gains derived by a resident of a contracting jurisdiction from alienation of shares and other rights of participation in an entity may be taxed in the other contracting jurisdiction, provided that these shares derive, etc., etc., etc. So here, basically, what MLI Article 9.4 says, the compatibility clause says, 9.4 shall apply in place of or in absence of a CTA provision, providing that the gains of a real property company, when how it will be taxed. So the compatibility rule is now will ensure that MLI Article 9.4 will apply in place of or in absence of a DTAA provision in relating to our capital gains of real property companies. So this is the compatibility rule. Based on the compatibility rule, we go further. The existing CTA provision is this, and the MLI Article 9.1 and 9.4 as reproduced here. So 9.1, of course, will not apply. We saw that it has been when 9.4 applies, 9.1 will not apply. That is the rule in MLI Article 9, and 9.4 is reproduced here. So as a practitioner, my job would be to see how this 9.4 will apply in place of 13.2. One, I can decide it to straightaway substitute 13.2, or it can be only certain aspects of 13.2 gets substituted. It is not an outright substitution of 13.2, which would be in effect like a protocol. It will not act like a protocol. A protocol which we see for a treaty will always substitute the existing article. Here, no, both are to be read alongside. So both exist at the same time. And to the extent the compatibility clause allows you to override, if that's the right word, override the existing article through the operation of the new article, which is the BEPS article. That is the way in which we read this provision. But there are certain problems which you will come across when we see this. But before that, let us go to the left panel. Left panel tells you what are those agreements which are CTAs relating to which are CTAs because both India and the other country have notified them to be a cover tax agreement. Now here the details of the cover tax agreement is given here. There could be multiple. There could be original agreement plus a protocol or what they call an amending agreement will be possible. Like for instance, I recall in New Zealand, for instance, you'll find more than one agreement. Yeah. So we have original amending instrument. So there are multiple agreements possible. So this will again tell you what are those. I think there's one third one also. Right? Let us see. Yes. The multiple agreements available in New Zealand, which are CTA agreements. So one has to, it is not that it is required for an agreement to be a CTA, a cover tax agreement, before any impact can take place because of MLI. Now there are other things also here. One other aspect which this tool could help is basically this, which is basically the mismatch in notifications. There are instances of mismatches in notification which you will come across when you look at when you start using the tool, or for that matter, start applying the MLI provisions. One or two mismatches I'll take you to. Let us take Lithuania. Let us take Article 7, which is basically your PPT article. So now this is Lithuania PPT article is there. Impact summary in here would contain all the articles of Lithuania, all the MLA articles relating to Lithuania, what is applied, what is not applied, what is changed and what is not changed. So we are on the detailed view. In detailed view, in Lithuania, both countries have not reserved Article 7 because Article 7 is a minimum standard. Both countries have not reserved. While India has notified Article 31 and 32. While the other country, as Lithuania, has notified only Article 31 containing the PPT rule. This amounts to a mismatch, right? A mismatch is basically where there is no matching between the notifications done by both the countries. The impact of mismatch, what is it? Would that mean the MLI change fails? Or would it mean that it has to be read down? Or would it mean that there is no conflict at all? Because it's quite possible that there might not be a conflict, even though there is a mismatch. Because notifications are just informative. They are supposed to give an indication of what the changes due to MLI are to be expected. So each country gives that notification so that you know that this is the article which the country believes will get modified, will get amended. So now let us just examine this in a little more detail. Now here we have a compatibility clause which says a minimum standard, so we don't need to worry too much about it. This basically shall apply in place of or in absence of. So if there is something relating to PPT in the existing treaty, it gets the MLI Article 7 will apply in place of that treaty, that provision. If there is no such provision, it will apply in respect of that treaty anyway, being a minimum standard. So now let us see how do we interpret this. Article 31 and 32 modified is what is our explanation. Here what it says, Article 7.1 would apply and replace the existing CTA provisions as both CJs have notified the same via MLA Article 717A. Now 17.1 would apply and supersede Article 32 to the extent of incompatibility, as India has notified 32, but other country has not notified 32. So let us look at the existing CTA provisions here. 31 and 32, and we have 7.1, which is the MLI article. Yeah, this is the PPT article. Here we have 31. It says benefits of this agreement shall not be available to a resident of a contracting state with respect to any transaction undertaken by such a resident if the main purpose of the creation or existence of such a resident or of the transaction undertaken by him was to obtain benefits under this agreement that would otherwise not be available. This is the existing CTA provision. Article 7.1, MLI Article 7.1 would apply and replace the existing provision. There is no confusion there. So 7.1, which is the PPT rule, would replace the existing PPT rule in 31. Since both India and the other country have notified 31. But question comes to 32. India has notified 32, while the other country has not notified 32. So what does 32 says? say, where by reason of the provisions of para 1, a resident of a contracting state is denied the benefits of the agreement in the other contracting state, the competent authority or of the other state shall notify the competent authority of the first mentioned state. So now here there is an obligation. If India is going to deny a resident of Lithuania through application of Article 7, MLI Article 7, the PPT article, it has to notify the competent authority of the other state. Is that incompatible to denying a treaty benefit through Article 7.1 of the PPT? That is a PPT rule. So I believe it is not incompatible. So even though India has notified 32, 32 will not get replaced because other country has not notified 32. So when both countries have not notified or notified, both countries have not notified or only one of them has notified. In that case, the rule is the particular provision will get amended to the extent of incompatibility. If there is nothing incompatible, the provision continues. So here I believe that is my interpretation that 32 will, though India has said 32, India has notified 32, 32 will not get modified because 32 is not incompatible with PBT rule. All that is required in 32 is informing the other state that that state's resident is being denied a particular benefit, treaty benefit because of the PBT rule. So this is the second level of interpretation, the gaps which I was talking about, which one will come across when one starts looking at the MLI provision in greater detail. And this tool helps you to bring it out in the sense that it's like it's in your face. Now it is up to you to decide whether 32 applies or not apply, whether 32 will continue to apply, whether there's an continuing obligation of Indian competent authority in case it denies a treaty benefit due to the operation of PPT to inform the other competent authority. India will say no, it is not required. But I would believe, going by the MLI provisions, there is a need to examine whether the Article 32 is incompatible with Article 7, even 7.1 of MLI Article 7.1. Only in that case it gets replaced. I'm using the word replace in a loose manner, or shall we say it shall apply, and not generally. So Article 32, in my view, will continue to apply. There will be an obligation for India to inform or notify the other competent authority of the other contracting state. So that will not go away. So this sort of issues will come up. There are several provisions where you will find this sort of gaps. Like for instance, let us take Estonia. Okay. In Estonia, again on Article 7 only, 28 through 24 is what India has said will get changed. While the other country has notified only Article 28.2, does not notify 28.3 and 28.4. Then what happens? So one other point, this I can go to full screen. Sorry, I should have mentioned that earlier. So it's easier if people are inclined to. Easier viewing if you have it on full screen. So now what we have here is Article 28.2 is what Estonia has notified, while India has notified 28.2 to 28.4. Then what happens here? Let us see 28.2 is something similar to your PPT with respect to any transaction undertaken by a resident. The main purpose of, one of the main purposes is the creation of existence of a such resident or transactions undertaken by him to obtain benefits under this agreement which would not otherwise be available. 28.3 talks about cases of legal entities not having bona fide business activities shall be covered by the provisions of this article. And what does 28.4 say? It shall notify. The one competent authority shall notify the other competent authority. The point is, going by whatever we discussed for Lithuania, even 28.3, the cases of entities not having bona fide business activities shall be covered under this provision of this article. So are we saying that If this gets removed because of India's notification, which would mean then I don't have this bona fide business activities condition existing any longer. Or can we say that bona fide business activities condition will also add on to the PPT rule? So the call is yours as a professional to take an interpretation. I hope you followed what I said. 28.2 gets amended because both countries are notified. Okay, that's the PPT rule will come in place of 28.2. 28.3 talks about case of legal entities not having bona fide business activities shall be covered by the provisions of this article. Right? And 28.4 talks about notification. So let us keep notification aside for the moment. Let us look at only 28.3. If PPT rule applies and PPT is getting, because of PPT, a relief is getting denied, but the entity is a bona fide business entity. It's got bona fide business activities. Can the entity then argue that no, I have got bona fide business activity? 28.3 is not replaced because the other country has not notified 28.3. In such a case, my PPT rule has to be read down, because otherwise I am having a bona fide business activity. Maybe a particular transaction or a particular item of income has fallen foul of the PPT rule, but I have had bona fide business activities. Can one take that defense and get away from the application of the PPT rule? My view, it is difficult, but point is, this is something sort of an argument. This possible. This sort of controversies are going to come in the coming years once you find litigation reaching the courts, reaching the higher courts, or maybe a tribunal and the higher courts. So this something I just wanted to give you a flavor of what this tool helps us to do. This tool brings on all the required data on a single page so that you can take a call of, and you can it helps you in interpreting the particular provision in a more in an easier manner. Of course, as I said, you need to go back to the legal documents to ensure that you are interpreting the correct thing. Apart from this, the mismatch and what we discussed here, let us see what other things. I'll have to go off because it's like wait. Okay, now there are two other things. I also have the synthesized texts, which I've captured here. Right? The synthesized text tells you, the synthesized text is basically sort of an exercise, an effort by the OECD to make things, make MLI more acceptable to the countries concerned. Synthesized text is not a legal document, and there's a big disclaimer on the front page of any synthesized text you see. You cannot really depend on it. There are mismatches even in the synthesized texts between what the two countries have published. There are also situations where only one country has published the synthesized text, the other country has not published the synthesized text. So really, you cannot depend on the text for any great reason. According to me, the text is available. You can refer it, but that is all there is. There is nothing much more you can do about it. I'll take you to one or two synthesized texts so that you get an idea. Let us take France. So I've given the basis of preparation. India, this is synthesized text issued by India. This is synthesized text issued by the other country. It is also possible that the synthesized texts there's only one synthesized text issued after both countries collaborate and come to a common synthesized text. It's also possible that both countries consult each other and publish a synthesized text as a shared understanding of the modifications. That's what they understand between the two countries. Actually, it is between the two competent authorities. It is not, as I said, it's not a legal document. It is not issued by any notification or anything. This is just again, maybe another tool, you can call it that. But I believe it is like a lot less useful than our MLI tool. Now here it talks about a shared understanding of the modifications made by the CTA, made to the CTA by the MLI. This is what India says. What France's synthesis text says. Synthesis text published by France for its treaty with India, specific to India. Document is prepared by the other. This document has been prepared by the by France. No mention there of consultation or discussion with competent authority of India or of any shared understanding of the modifications made to the CTA by the MLI. India believes it is shared understanding. India also says there have been consultations. The other country refuses to acknowledge the consultations, nor do they say the understanding is shared. One aspect here is also interesting is that France has issued a consolidated text. It is not even a synthesized text. A consolidated text is basically making the changes to the existing treaty as if the MLI is a protocol. They have modified the existing treaty to say how the existing treaty will look like if the MLI once the MLA has modified that treaty. Yeah, and I put document not available because it's in French. So I made to translate it, then this will get updated. So the point I'm making here is that there are differences even between the synthesis text published by India and its treaty partner. Also, synthesis texts per se do not really help in the sense that you will find the synthesis text will just give the MLI text or the text of the MLI article in a box underneath the relevant treaty article, but it doesn't really tell you how that new text, the MLI text, impacts the existing treaty provision. That you will still need to do your own interpretation, and you will find the courts doing their own interpretation, and you will have litigation going forward. Though the extent of changes because of MLI is pretty limited, very few articles are getting affected. But where they are getting affected, you have these sort of problems of interpretation. Now, lastly, I'm unable to move the. Sorry. We have a user manual, so if people can have a look at it. If they have any doubts, they can have a look. They can click on it. You can look at it. One thing is, after you select something, you will probably need to click on some other place. Let's say I select Armenia. The drop-down box doesn't close on its own, so you need to select somewhere else. This is because of the Looker Studio in which it is made. That there's a basic issue with that software. And there is no workaround that. So if I get a workaround, we'll get it amended. But otherwise, it's a minor thing. It can be sorted out. Now, this snapshot, this is the last thing which I want you to have a look at. This sorts of gives you what it is, what it says it is. It's a snapshot. A snapshot is nothing but tells you sort of a bird's eye view of the impact of MLI on India's treaties and the extent of its impact. Like for instance, if you see here, this column is, let us say, modified by the MLI. So if you see the highlighted portion, it sorts of acts like an X and XY axis cross. So you come here, let us say, you want to know how many treaties are modified by Article 7 SLOB. Right? So you come here, you click on this. On the right panel, you get the name of the 12 countries whose treaties are modified because of the SLOB article. Right? So same way, let us say you want to look at elimination of method of elimination of double taxation. How many countries articles get affected?
Yeah.
Wait a second. I'll have to check. So if you face such problems, you do a reset, it will get sorted out. 65 countries have come here, list of prevention of treaty abuse. So let me see why this has happened. I'll check it out and get it sorted out. There's a hitch. So this snapshot tells you at a glance, like how many treaties are modified here, modified by MLI, how many are reserved or opted out by India, how many are reserved or opted out by the other CJ, other contracting jurisdiction, how many are reserved or opted out by both the contracting jurisdictions. And lastly, which is not a CT at all. Basically, there are around 30 countries with which India's treaties are not impacted by MLI because the other country either has not signed the MLI or has not notified India's treaty as a CTA, like for Mauritius, like Germany. And you also have where BEPS issues are covered. This is so BEPS issues is absent or addressed in DTA. Either the BEPS issue itself is not there in the DTAA, or it is addressed by a bilateral arrangement. So this is the benefit of the snapshot. You get an overview of the impact which MLA has on India's treaties. Other than that, if any other questions are there, then I'm ready to take them. It's too late. Was the voice inaudible?
No, not at all.
Because somebody felt it is inaudible.
No. I think it is fine.
So happy to take any questions.
So I think so. Yeah, Ashish says very, very information and helpful. Yeah.
Thanks, Ashish.
Hmm.
You should unmute him. You'll have something to say. Which is good.
Yeah, I think we have a little bit of time constraint
Okay, fine.
right now, sir. I'm more than happy otherwise. A little bit. Many thanks, sir, for the wonderful session. Very insightful. And I think now our subscribers would be quite conversant, and especially they'll get more familiar once they use the tool. This is again available only to subscribers of Taxsutra's portal, and of course we've given the link on the homepage of Taxsutra. We have one more comment saying appears to be a very useful tool. Thanks.
Thank you.
Thanks so much, sir, for the for your time, for taking this training session. And just in case anyone has any issue while accessing the tool, please feel free to reach out to our team and your relationship manager. Thanks once again, Ganesh, sir, for your time and for the collaboration.
Thank you.
Thank you, everyone.
Thanks,
have a nice, relaxed weekend.
Thank you.